some of you, I think, are still at school expecting to go to university to study law in the near future. So I hope those observations have been helpful. The topic today is a really timely one that is affecting every jurisdiction in the world. We all have to learn the law of evidence, and sometimes it's a little technical, and certainly when I was a student, I would scratch my head and wonder why some of the rules existed. But essentially, they exist for two reasons. The first is to ensure that only relevant evidence goes before a criminal court. And the second is to ensure that the process by which that evidence is admitted is fair. And in dealing with electronic evidence, the courts are grappling with a rampaging development in technology, and in all jurisdictions are actually struggling to keep up. In the old days, long before even I was a student, courts had to grapple with, well, what do we do with banking evidence when it was all written down in ledgers? Nobody would be able to remember writing the entry. And so there was legislation across the world that enabled that sort of evidence to be admitted. And then business records, then photographs, then tape recordings, then video recordings, the old-fashioned video recordings. And now it's electronic evidence. And the real problem is that although in 90% of cases, there's no controversy about the electronic evidence, it's on the phone, it's text messages, it's WhatsApps, whatever it may be. But it's, as was pointed out by one of our speakers, it's so easy to fake it now that you have to have a system that is fair in enabling all the electronic evidence to come in, but is also nimble enough to pick up the fakery. And that, I think, is quite difficult. But all of us were immensely impressed by the quality of the debate that we heard. I hadn't realized that you'd only had 4 days to prepare, so I'm now even more impressed than I was. All of you were very fluent, and I can see that all of you have a good future ahead of you as lawyers. Nonetheless, we have to make a choice, and making choices is always both difficult and a little invidious. And having considered the debate very carefully against the criteria that we were asked to apply, the unanimous decision of this panel is that the proposers won the debate.
A big hand clap for them. Before you sit, Lord Chief Justice, if I could just have you present their tokens of appreciation. Maybe you could stand so that, if you may, please. The tokens of appreciation were donated by Mr. James Ochieng Oduol, Senior Partner at Triple OK Law Advocates. Present for the runners. Runners up, if you could just come to the front. Everybody is a winner. Yeah, he's supposed to help you as well. Honorable Ndieki, for our facilitator, timekeeper student, who doubled as the court administrator, a token of appreciation. Thank you very much, gentlemen. We will now move to the refreshments. We had planned to have an open session, but the weather has not been kind to us. So I will have my panelists move to the deliberation room. I will invite the debaters to join the panelists for the tea break. Students from Strathmore. How many students came from Strathmore? If I could have 3 of you also join the panelists in the room. The rest of you, if you could just maintain. The room is not big enough to accommodate everyone, but we are trying to set you up. And what will happen during the tea break, if the panelists are done with their tea break, they'll come and join you downstairs. Please allow us. So if the panelists could lead, followed by the debate team, followed by... You'll come back, please observe time. We'll come back in 20 minutes. In 20 minutes, the Lord Chief Justice will deliver his paper. So if I can have the panelists, the debaters, invited guests from Law Society, Commonwealth Law Association, and the 3 students from Strathmore join them in the holding room for refreshments. We come back in 20 minutes. My timekeeper is still here and on duty. Observe silence, phones on silent, as I hand over the second part of this program to Dr. Mutai. I want to thank you for coming back, and I also want to thank you for participating in the first session. My name is Janet Otero. I'm a partner at Triple OK Law, practicing in the Tech and Telecommunications Department. Dr. Henry Mutai.
Good morning once again, and thank you for joining us. Without any further ado, because we are operating on a very tight schedule, it is my pleasure to invite our chief guest today, who is the Lord Chief Justice of England and Wales, the Right Honourable the Lord Burnett of Malden. He is the head of the Judiciary of England and Wales and the President of the Courts of England and Wales, a position that he has held for the last 6 years since 2017. His key responsibilities, in case you're wondering what a Lord Chief Justice does, are representing the views of the Judiciary of England and Wales to Parliament and the government, welfare, training and guidance of the Judiciary of England and Wales. He discusses with the government the provision of resources for the judiciary, which are allotted by the Lord Chancellor, the deployment of judges and allocation of work in the courts in England and Wales. So he is appointed by a special panel convened by the Judicial Appointments Commission. In practice, the Lord Chief Justice and heads of division are generally appointed from the Court of Appeal. However, appointments can also be made from the Supreme Court. Our time is very tight this morning because he has another appointment that he has to be at by 1 o'clock. So without further ado, I shall invite the Lord Chief Justice to make his remarks, after which we shall have a very brief Q&A, after which you shall excuse him to continue with his other engagements. So, Lord Chief Justice, the floor is yours.
Well, good morning again, and it's good to see you back. I appreciate that it's Monday morning, and many of you will have spent the weekend at leisure, and I guess many of you will have spent the weekend watching football. But it's back to the law now. I'm going to give you a relatively brief address on judicial independence and accountability, touching on the rule of law. And then what I hope will happen is that you'll be able to ask me questions, not necessarily about the topic I'm talking about, but anything that you think might be interesting to ask me. And having been watching the debate, the moot a little bit earlier, I've come to the conclusion that Kenyan law students are not generally shy, as lots of them are in the UK. So my focus this morning is, as I say, judicial independence and accountability in the 21st century. So what challenges are faced by judges across the Commonwealth? What opportunities are generated by robust and responsible judiciaries? My starting point is a description of the much celebrated but notoriously elusive concept, the rule of law. For some, this is a constitutional lodestar, but others think it's an empty slogan. Some think it's the preeminent legitimating political ideal in the world today, even if it lacks agreement on precisely what it means. Its essence is illustrated by a story told by the great 18th century jurist, Sir William Blackstone. The tale concerns the Russian ambassador to London of Peter the Great in the opening years of the 18th century. One morning, the ambassador was pulled from his coach and arrested for an unpaid debt. The Tsar, Blackstone tells us, quotes, resented this very highly and demanded that the officers who made the arrest should be punished with death. But the Queen directed her minister to inform him, quotes, that the law of England had not yet protected ambassadors from the payment of their lawful debts, that therefore the arrest was no offence by the laws, and that she could inflict no punishment upon any, the meanest of her subjects, unless warranted by the law of the land. So in this steadfast retort, more than 300 years ago, we find the crux of the rule of law. Two key tenets, like the poles of a magnet or sides of a coin, oppose and yet depend on each other. First, no one is above the law. Second, no one is punishable except in accordance with the law. This basic constitutional foundation is forever being built upon. A decade ago, Lord Bingham, one of my most distinguished predecessors, described 8 features of the rule of law. More recently, Lord Hodge, the current Deputy President of the Supreme Court, has identified 10 to support a fair and effective legal system. At the heart of both accounts is the ideal of judicial independence, which is enshrined in the 4th Latimer House Principle and in Section 160 of Kenya's Constitution. For the purpose of analysing that constitutional ideal, I'll restrict myself today to 7 key principles. Together they help to answer 2 questions which must be asked of all judicial institutions. How can judges be insulated from improper influences? And how can they gain and retain the public's trust? The first principle is that the appointment of judges should, so far as possible, be free from political influence. In countries where independent bodies appoint judges, transparent criteria should be published to foster confidence in the judiciary as individuals and as an institution. In countries whose constitutions involve the executive in judicial appointments, an understanding that such decisions should be made on merit must prevail. Little can be expected in the way of intellectual independence from judges who are installed on nakedly political grounds. The second principle is that judicial training should also be independent of political control. Although often overlooked in discussions of the rule of law, I suspect that the importance of accessible, free thinking and high-quality legal training needs little elaboration here. A third principle is that the judiciary must be adequately funded. Judges must be remunerated properly if their quality and impartiality are to be maintained. Crucially, this depends upon the support and cooperation of government and parliament. Once secured, that funding must be protected to avoid salary changes being wielded as a tool for manipulating judicial decision-making. Judges must be in nobody's grip and in nobody's pocket. My 4th and 5th principles can be dealt with together. They are security of tenure and judicial immunity from suit. It's not difficult to come by examples, historical and present, of judges being removed from office for acting with integrity or being sued for failing to decide cases in the right way. You will know that that happens in many parts of the world. In Britain, in 1686, King James II sought to sway a case in his favour by threatening the judges with dismissal. Sir Thomas Jones, then head of the Court of Common Pleas, was unwavering in his response. "For my place," he said, "I care little. I am old and worn in the service of the Crown. But I am mortified to find that your Majesty thinks me capable of giving a judgment which none but an ignorant or a dishonest man would give. Your Majesty may find 12 judges of your mind, but hardly 12 lawyers. So unbiased and unflinching judges like Sir Thomas are the natural foes of would-be dictators. And in the standoff between them, security of tenure and immunity from suit are the strongest of judicial shields. Without these protections, judges would depend on maintaining favour with those in power. Put simply, precarious judges are pliant judges. That's not to say that judges should be answerable to no one. Indeed, my sixth principle is accountability, albeit accountability of an independent kind. The most obvious such mechanism is appellate review, by which judges are accountable for their decisions. Appeals drive up judicial standards and help to mitigate public resentment against apparently wrong decisions. Judges should also be accountable for their conduct. They should be subject to disciplinary action, including dismissal if necessary. Were judges able to act in ways that brought the judiciary into disrepute without fear of redress or sanction, public confidence in the institution would soon wane. But discipline must, at least largely, be in the hands of judges themselves. That brings me to my seventh and final principle, which is closely connected with accountability. It's the principle of open justice. Through publishing and explaining decisions, through engaging with civil society, and through allowing access to the courts in person and now, of course, by broadcast, judges must always strive to make their work transparent. Jeremy Bentham, that great philosopher, described this endeavour as, quotes, the keenest spur to exertion and the surest of all guards against improbity, close quotes. It's essential to public confidence in the law, which in turn is essential to the moral authority of judges. Now, judicial institutions shaped by these seven principles are sure to be independent and robust. And societies with such judiciaries are well equipped to withstand exploitation by powerful actors, such as governments, corporations, trade unions, and others. That is why the separation of powers was so central to the constitutional philosophies of great philosophers in the United Kingdom, in France, and the founding fathers of the United States of America. Expressing this ideal in more straightforward terms, a British politician once defined a constitution as whatever government can get away with. And nobody wants to live in a country where government can get away with whatever it likes. Judicial independence, however, is not just about restraining power. Quite the opposite. For history has shown that the independent judiciary is a potent engine for prosperity and a boon to economic enterprise. Academics have cogently argued that a commitment to the rule of law, overseen by an independent judiciary with a vibrant and independent legal profession, has underpinned the growth of societies across the world for at least the last 300 years. One need only compare the rival histories of East and West Germany after the Second World War, or of North and South Korea today, to feel the force of this point. No wonder the United Nations has named good governance and the rule of law as one of its sustainable development goals. So where judges deliver accessible, impartial, and high-quality dispute resolution, businesses will flock. Where litigation is difficult, expensive, or vulnerable to external influences, they will flee. A study conducted by the Bingham Centre for the Rule of Law and Hogan Lovells, a large London law firm, found that 95% of businesses identified a lack of corruption as an essential or very important factor in whether they would do business in a jurisdiction. But the economic benefits of a legal system overseen by an independent judiciary extend far beyond the courtroom. For there's a hidden value to the rule of law, which corresponds to what is sometimes called the shadow of the law. More often than not, the knowledge that disputes can be resolved in a fair, efficient, and predictable manner enables individuals and business to avoid those disputes in the first place. Parties are more likely to contract if they have a common understanding of the law and know that judicial remedies are readily available if things go wrong. They are more likely to abide by their agreements if they know the consequences of breach. In this way, an independent judiciary provides a stable launchpad for confident investment and economic growth. But for all this, the value of an independent and accountable judiciary is not just instrumental. As I've said before, no one would propose that the worth of an education system could be calculated purely by adding up its monetary contribution to society. An educated society becomes more prosperous. The same, I suggest, should apply to our legal institutions. To reduce an independent judiciary and the rule of law to its economic value is to miss its true worth. Indeed, as St. Augustine provocatively asked, what is the difference between a kingdom and a band of robbers? Both are rule-bound, money-making enterprises after all. For St. Augustine and his commentators, the difference is that in an ideal kingdom, at least, the rules are intended to secure good or just outcomes. But there is another, more fundamental distinction to be made. In a band of robbers, the rules are simply a means to an end. Their sole purpose is to tell the robbers how to divide up their loot. But in a society where the rule of law is overseen by an independent and accountable judiciary, the rules have an intrinsic moral value. They embody individual citizens' rights to be free from arbitrary control and to have a fair opportunity to be heard. In this way, their very existence respects the basic dignity of all. For this reason alone, the courts should not be regarded as an ordinary public service. The value of judicial independence, therefore, cannot be overstated, nor can its durability in the 21st century be taken for granted. It depends on the continuing existence of healthy cultural norms. Citizens must understand and support the role of the courts, which is why the principle of open justice is so important. The political institutions of government and parliament must accept, often to their frustration, that respect for the rule of law means recognizing limits on their own powers. As Professor Geoffrey Giles has described, they must abide by a self-imposed institutional morality. Now, as all of you know better than I, this delicate constitutional balance came under scrutiny not so long ago in Kenya, when in 2017 and then again in 2022, the Supreme Court was asked to review the legitimacy of presidential election results. For obvious reasons, I make no comment at all on the causes or outcomes of those decisions. But I do remark upon the significance of their subject matter. For in those cases, so many of today's themes were on display, chief of which being the right to challenge decisions of public importance under a constitutional framework that respects the separation of powers. But to appreciate perhaps the most significant aspect of these cases, we must look beyond the courtroom. To my mind, what is most remarkable about cases of this kind is not the willingness of judges to confront difficult constitutional questions, but the willingness of the parties and the public to accept their answers, notwithstanding any personal misgivings they may have about the outcome. Losers' consent is a crucial but often overlooked aspect of the rule of law. It is a direct product of judicial independence and accountability. Only when parties feel that they've had a fair opportunity to be heard, and only when they regard the court's view as impartial and authoritative, will they be willing to live with decisions that go against them. Importantly, the moral authority of judges depends upon their recognizing that institutional independence is not a one-way street. Just as ministers and legislators must stay within their constitutional provinces, so it is with judges. It's trite to say that the court's jurisdiction goes no further than the law. But what that means in practice is that judges must develop what I've described as an allergy to politics upon assuming office. To feel the force of this point, again, we need look no further than the 2017 and 2022 election judgments, when, if I may say so respectfully, the independence of your judges and their bravery was on show to the world. As the Supreme Court recognized in the first case, flawed decisions are susceptible to judicial control. But as it recognized in the second, fair and proper election results are consecrated even before courts of law. To observe the limits of judicial power in this way is to gain more authority, not less. And in the words of the late Sir John Laws, one of our very distinguished public lawyers, public confidence in the courts would not be enhanced by a diminished judicial respect for the authority of the ballot box. What emerges then is an important responsibility. With judicial power must come judicial restraint. Judges who do not observe the proper boundaries of their constitutional role will, I fear, soon lose their authority and then their independence. That is the constitutional balance judges of the 21st century must eternally strive to uphold. There's one final challenge I wish to confront. It's one that concerns individual judges as opposed to institutional judiciaries. Judges must not only be independent and accountable, they must also be brave. As one of my predecessors, Lord Judge, observed, judges must have moral courage to make decisions that will be unpopular, whether with politicians or the media or indeed the public. And perhaps most important of all, to defend the right to equality and fair treatment before the law of those who are unpopular at a given time, indeed particularly those who for any reason are unpopular. Now, I began today with Blackstone's tale of Peter the Great calling for the heads of those who arrested his ambassador. As we've seen, it's a story at its heart about the rule of law, but it's also a story about moral courage, the moral courage of individuals charged with carrying out the law's demands in the face of powerful threats. It's the same moral courage which was shown by Sir Thomas Jones when he refused to bend to James II's will, and by the Supreme Court justices of your country in the recent election cases. Blackstone's story shows us what's at stake when individuals bravely step forward to uphold the rule of law. But I have to say that despite the Queen's defence of constitutional principle, some of the arresting officers were imprisoned for their impudence, although not for very long. Sir Thomas lost his job for defying the King. The independence and security of judges may be much improved in many countries today, but even in the 21st century, there can be no complacency about the weight of this judicial burden on individuals around the world. In order for judges to stand alone, I believe that judiciaries must stand together, both within and across their respective jurisdictions. Judicial independence requires judicial interdependence. Judges in positions of leadership must set the tone by cultivating a judicial culture which encourages independence, fosters collegiality, and supports individual resilience. Judiciaries around the world must continue to engage in dialogue, and they must exchange ideas, sharing with and learning from one another. Commonwealth judiciaries are well placed to engage in such exchange, sharing as we do a close legal heritage through the traditions of the common law. Never has this been more apparent than when our judiciaries, through the Commonwealth Magistrates and Judges Association, played a crucial role in the development of the Latimer House principles to provide a common framework for understanding judicial independence. Through that collegial dialogue and through that common understanding, we can continue to support each other to maintain our independence and to uphold the rule of law. It's in that spirit that I thank you for inviting me here today. Now that's the end of the formal lecture. So I hope now that, Professor, you might be able to curate questions and we might have a little bit of fun.
Thank you very much, my Lord, for those very useful and insightful remarks. We have been speaking here to the next generation of the legal profession, and I am sure among them are future members of the bench who will have taken those remarks to heart. So, can we have maybe about 10, 15 minutes of interaction, please? If you want to raise a question or a comment, state your name and keep it brief. Maybe you can start from that end, that side. I can see very many hands, but let's go the lead. Oh, you already have someone in the mic. Okay. Mwaniki. And then from there, at the back there, brief.
Can you clap? Thank you very much. I have two very simple questions, I think. One, rule of law is all very nice, and most people agree it's a great thing. But what if the law is bad? Once upon a time, slavery was supported by the law. Colonialism was supported by some law. Apartheid was supported by some law. Now, what if the law is bad today? Whether it is international law or municipal law, what should we do as lawyers about bad law? And what should judges do about some law that they consider to be bad? Is there a moral authority to obey an immoral law, for example? Thank you very much, my Lord. My other question is on a light note, which is the following. Once upon a time, all the judges in England were actually nobles. They were from the nobility. They were actually lords, and they were all men. Today, I suspect we have a number of judges who are not from the nobility, strictly so called. They are commoners. Why do you still call them lords? What gives them a right to be called lords? And the ladies, the ladies. Some of my colleagues have a bit of a problem calling women judges my lady. Now in Kenya, Your Lordship, in Kenya, we borrowed that tradition from England, and we call all our judges lords, but none of them, not one, they are all commoners.
Thank you. There was a hand
from the village. Thank you very much.
The lady over there.
Good morning, everyone.
Yes.
Good morning. So my name is Himani Masi, and I have a question for His Lordship. In regards to separation of powers, I want to bring into context the whole idea of the global south and the good governance courts, and how our magistrates and our judges need to, like the demarcation of separation of powers, it's not quite clear, especially for the global south countries. I was being a member of that category. Now, for example, how our judges are required to make some policies which are exclusively left to the executive. Now, what do you have to say for that? Do you feel like the judges and the courts on the global south have more to do in comparison to the global north? Do you feel like our country, for the judges, the lines of separation of powers cannot be quite as clear like was the proposition by Montesquieu? What is your proposition on that?
Thank you. Then at the back there, one more. And then we'll move to the middle. We have two. We can take the lady here. So yeah, you can give her the mic, then she'll be.
Good morning. My name is Eugene Akumu, a member of Class D. So my question is regards to the third principle that the judiciary requires adequate funding. Be that as it may, how practical is it to separate that from the executive? I'll give an example of our country, Kenya, where the Finance Public Management Act requires the CS of National Treasury and Planning to submit the finance bill to the National Assembly. So who appoints the cabinet secretary? It's the ruling government, which forms part of the executive arm of the government. And when you also look at the majority of seats, considering our electoral system that are held by the National Assembly, it's always the ruling party, the executive. So I just wanted to inquire how in the UK you are able to separate and actually secure adequate funding for the judiciary. Thank you.
Good morning. My name is Grace Zawadi Walioli from Class B. I would like to start by appreciating you for that very stellar presentation on the rule of law and judicial independence and accountability of the judiciary. I think I'll just make a short comment that you are very well placed to address us on judicial independence, given the work that you have done in your tenure as far as ensuring that the executive respect the judiciary. And in your words that MPs must learn boundaries, I thought that was very potent, especially in this time for our country. My question has a little to do with the presentation you have done. I think now that you are here, could you kindly address us on R versus Pinfold 1988? So it was a decision by the English and Wales courts, basically determining that criminal appeals must be done only once. And that after they have been done once, there must be now upheld the principle of bringing an air of finality to litigation. I considered that and I thought that it's just unjust because, especially in that particular case, there was further evidence that was adduced after the first appeal had been made. Isn't that quite problematic? I'd be interested in hearing your opinion on that. Thank you.
Thank you. And then maybe one more for, this gentleman here, and then.
Thank you so much. I'm Brian Okoth again. My question to you is with regard to judicial language when rendering opinions by judges. Many a times, and we understand from what you've presented, is the judicial immunity from suit. So probably from a recent case that is ongoing, there was a discussion around the judicial language with which the judge rendered her decision, to the point that some felt it was defamatory to the accused, whereby she referred to the accused as a man-eater and a male version of a slave queen, which probably we don't know the import of it. But what is your view on the unfettered judicial immunity with regards to rendering decisions? Thank you.
Thank you. Good morning, everyone. Your Lordship, your Lordship, the Justice.
Just introduce yourself, your name, and then your question.
Okay. My name is Ezekiel. I'm Ezekiel Kali from class E. So your Lordship, the Chief Justice, thank you for giving us a lecture on the rule of law. And from that, I have a question. What is the extent of the immunity of the monarch and the Prime Minister in UK? And by extent, I would wish to hear your comment on the immunity on imperial presidencies, which are occurring or are rising in the world currently. Thank you.
I'll give my fellow panelists the last question here, and then I'll invite the Lord Chief Justice to come and respond.
Thank you, Dr. Mutai, for allowing me the last question, if not the last word. Mine is completely out of academia. I'm not going to ask any questions about R versus Penfold. I don't even remember what that case is about. My Lord, I understand that you'll be retiring soon. Could you tell us, as a matter of interest, what do Lord Chief Justices do when they retire?
Thank you. I think you can come and take that set of questions first. Then, if there's time, we can come back.
Well, I've just been told I've got 10 minutes to deal with those 8 questions, which is even tighter than the debaters just before the break. The first question was a very profound one. And from time to time, there are hypothetical debates. What would happen if Parliament passed a certain law? What would the effect of it be? Well, there are constraints. At the moment, we have the Human Rights Act, which has brought to our domestic law the European Convention of Human Rights. But one of the tenets of the rule of law, as you know, is that nation states should abide by international law. They should abide by customary international law, and they should abide by their international treaty obligations. And so we have it's a theoretical thing, but we have a very strong presumption in the UK when interpreting legislation that we interpret it, if we can, in conformity with the international obligations of the United Kingdom. The reality, I fear, is that if, God forbid, a parliament somewhere in the Commonwealth were to reenact apartheid legislation, really what you're seeing is a breakdown of the rule of law that has led to the enactment of such legislation. And one can think of many other examples. And I ask the rhetorical question, suppose the case came before me and Parliament and the executive had decided to enact a law which was monstrous, and I said, you can't do it. What do you think their reaction would be? So I think we're moving into the realms of theory, but within any constitution, even ours unwritten, there are some very powerful tools in the hands of the judiciary to deal with unjust laws. Parliament should deal with unjust laws. And what happens too often is that there are laws which are passed with the best of intentions that have unjust consequences that weren't perhaps thought about sufficiently before the laws were passed. And in those circumstances, I think there is a job for lawyers, but judges can't engage in public debate about policy, but for lawyers to be active and articulate in identifying areas of the law which arguably are unjust, to encourage debate and to encourage change if that's what's needed. I'll come back, if I may, to why some of us are lords and some of us are not. Separation of powers and global south. Well, the separation of powers was always something of a theoretical construct which was applied in different places in different ways. And the UK was the worst, absolutely the worst, because until less than 20 years ago, the Lord Chancellor was a member of the cabinet. He was head of the judiciary, and he was also presiding officer in the House of Lords, the Speaker of the House of Lords, our upper house of Parliament. So he occupied apex positions in all three branches of state. And that was changed by legislation. And now the Lord Chief Justice is head of the judiciary. There's a Lord Speaker in Parliament. And he remains a cabinet minister, but has no judicial functions at all, but is deeply involved. He's responsible for government policy to improve things and also may well know. determine difficult evidence in one form or another, which will be limited. And so I do think that judges have to be very careful to recognize that if, for example, and here's an example that we've had in the UK, litigation about assisted dying, very, very sensitive and difficult topic, but one which, for my part, I think the judicial process is really not very well equipped to determine. Then we had funding. Well, yes, we require adequate funding. I observe semi-facetiously, but it's true, that there is not a single vote for any party in any democracy in funding the administration of justice. It simply doesn't resonate with the electorate, and the world over, the administration of justice, the courts and the judiciary tend to be squeezed, given enough money to keep the show on the road, but not enough money to do many of the things that we would like to do. And so we struggle, all of us, to get sufficient funds to modernize, to bring in new equipment, to keep our buildings in decent order and so on. And none of that is alien to what I have experienced in London. Actually, at the moment, I'm in discussions about the budget for the coming year, and money is always very tight. We have a statutory responsibility upon government to give adequate funding for an efficient and effective court system. So there are three words there that are very, very slippery. Adequate. Well, what do you think's adequate? What do I think's adequate? Efficient. Well, what do you think's efficient? What do I think's efficient? Effective. And so, although there is that statutory duty, it's not a terribly strong one. And it won't surprise you to know that I talk to many chief justices around the world, and there's only one I can think of, and I'm not going to name the jurisdiction, who tells me that he has enough money. Criminal appeals done only once. It's not quite as rigid as that, and it wasn't as rigid as that in 1988. It's true that in terms of ordinary appeals, criminal appeals and civil appeals, the parties are expected to bring their case and all of their case, and they have one crack of the whip. Across all jurisdictions, we have a safety valve, which allows exceptionally a case to be brought again if something quite extraordinary has happened. It's called the Taylor and Lawrence jurisdiction, if you're ever keen to look it up. But in the criminal sphere, there has been a different safety valve for as long as I've been a lawyer. In the old days, I was going to say, sounds awful, but it's true. The Home Secretary, so our Minister of the Interior, effectively, had power to refer a case to the Court of Appeal if something new had developed, which meant that there was a question mark over the safety of convictions. And I was deeply involved in that as a relatively junior barrister when I was engaged in the inquiry into the convictions of the Guildford Four, they were called. These were IRA alleged terrorists, and a whole family who were convicted of essentially bomb making. And those convictions through our work were eventually set aside. But it was put on a statutory footing. And so we now have something called the Criminal Cases Review Commission, to which anyone who's wanting to make a second appeal can present their cases, and then it's filtered by the commission, and they refer cases to the Court of Appeal, which they think have some prospect of success. So it's not quite as brutal as you were reflecting. Judicial language and immunity from suit. Well, how do we approach it? I encourage all judges to avoid using inflammatory language in their judgments. It's as simple as that. And we need to stop, don't we? 2 minutes, okay. I'll see. It's always said lawyers are hopeless at time estimates, but judicial immunity is really quite important because even in that context, it's possible for people to use complaints against judges as a tool to undermine them. And so one's got to be very, very careful about complaints that are made about the tone of language in judgments. The immunity of the monarch and the prime minister, well, the monarch is immune from suit, and there has never yet been a difficulty with that, because the monarch in most of his ordinary activities operates through institutions which can be sued. So it's very complicated, but the Crown's property and so on is held in their duchies, as it happens. That will come to lords in a moment, but duchies, and so they're subject to the ordinary rules. But if the king were, I don't know, caught speeding, I don't know what anyone would do, but I hope the problem doesn't arise in my time. The Prime Minister and all ministers are subject to the law, and all members of public parliament. So over the last 10 years, we've had many members of parliament who were prosecuted for fiddling their expenses. They were convicted and some of them went to prison. And the recent example, our recent Prime Minister was subject to the law over COVID restrictions in just the same way as everybody else. So the Prime Minister gets no special treatment at all. So two final questions. Why are we lords? Well, it's just a courtesy which developed 800 years ago, and so no one's had the courage to say we shouldn't do it. Some judges are lords. There are two of us who are members of the House of Lords, and there are other judges who have a courtesy title of Lord, but are not members of the House of Lords. Now, nobody understands the British system of honours and titles, nobody, and it would be folly of me to try to encapsulate it in the 15 seconds that I'm going to be told I've got left. What do Lord Chief Justices do in retirement? Well, a lot, I hope, a lot. Most of my predecessors have been active members of the House of Lords, the second chamber. We can't be active members whilst we're serving as Lord Chief Justice, separation of powers issues, obviously. And most have gone on to do some international judging jobs, a bit of dispute resolution and all sorts of things. So the way I put it at home is I'm not expecting to return home and grow turnips. I think I'll be quite busy, but I'll have control of my life again. But thank you.
Thank you very much. I want to acknowledge the fact that there were some online questions that were posed, but unfortunately, due to pressure of time, we will not have time to pose those or to take another round. Otherwise, Janet and Jennifer over there will never bring another guest to the school. So as we approach the end, could I invite Jennifer to come and give a brief vote of thanks before I also say some remarks?
Good afternoon, everyone. Lord Chief Justice, Honourable Ondieki, President of the Law Society, Acting CEO of the Council of Legal Education, and Dr. Mutai. All protocols hopefully observed, and forgive me for all the ones I got wrong if the order was incorrect. That's the privilege of a foreigner. My name is Jennifer Riddell. I'm the Criminal Justice Advisor at the British High Commission, and it's my privilege to be both a lawyer and a diplomat. I have a current practicing certificate for the jurisdiction of England and Wales, and if anyone wants to know why we have so many jurisdictions in the UK, please follow up with me later. But I would like to share a short vote of thanks because many, many people have been involved in this today. I hope you have enjoyed your interactions with the Lord Chief Justice, with this sage panel, and hearing all of your colleagues and contemporaries' feedback. I would like to thank our hosts, Kenya School of Law, and the hardworking team from the Law Society of Kenya, ably assisted by the Commonwealth Lawyers Association, for organising this wonderful event. Thank you also to the distinguished panelists for giving up your time and to share your wisdom and experience with us. This event did not come from nowhere. As soon as we heard that the Lord Chief Justice was coming to Kenya, we started to work closely with his office to create and curate a programme which we hoped would evidence the strong partnership and connection that the legal systems of Kenya and the UK share. We knew that we wanted to create an event that included students to showcase the future of the Kenyan bar. So my greatest thanks goes to you, all of you who have listened, participated, engaged, shared your insights on this important topic. You are the future of the bar, and I am confident that it is a bright future for Kenya. Thank you.
Thank you very much. I would want to repeat and add my thanks, firstly to the British High Commission for having organized this and for having thought of the Kenya School of Law as a partner in this public lecture, the Law Society of Kenya and the Kenya Judiciary Academy. We know that the Lord Chief Justice is here as a guest of the Judiciary. I'd like to also thank my Assistant Director, Anna Konuche, for having very quickly in a short time organized this debate, working with the candidate from Tupoloke here. I know they had to pay a couple of visits here to identify a suitable spot, and I'm glad that here at the school we do have the facilities for such a lecture, and we hope that in future we shall continue receiving guests to give mentorship to our students as the next generation of lawyers. So again, because of pressure of time, I shall not say much. We have a small token for the Lord Chief Justice that I will invite the President of the Student Council to come and present to him. This is definitely within the limits of the gifts that are permissible to judges, so you do not need to worry about that. So if I can ask you to come to the front and receive it from Thank you for having come to the school. We appreciate your visit and your public lecture. We can receive it together. And so with that, we come to the end of this. I think you'll agree with me that having had the Lord Chief Justice for the entire morning is a privilege that I don't think any other institution will have during this visit. And can we end with a loud round of applause for the Lord Chief Justice? Okay, thank you. We shall go out with the guest to have a quick photo session, and then he shall be off on his next appointment. Thank you all very much and have a good afternoon.